welcome, and thank you very much for attending my webinar on liquidations for accountants. I specifically present this webinar because in these trying times we are all very busy with people who are in financial trouble, and it's imperative that we help our clients to survive this pandemic and the economic havoc that it wreaks. Because with liquidation and the restructuring process, the way I do it, it is possible for clients to overcome this problem. There are businesses who will probably never open again, but then at least we can help the client to not suffer from the consequences of the financial war that's going to attack them once this is all over, because nearly everybody is in trouble and we need to help them. So I thought, you know what happens when you learn about liquidation at university or on a course or wherever, they don't teach you, the academics differ very much from the practice. So I thought, wait, just to help you to also help your clients, because it's important to me that we help business owners, I will show you how practically a liquidation works, not this academic stuff that they teach us. Okay, now my next challenge is to move slides. Okay. So today we'll talk about when do you liquidate, will your client lose everything, how do you keep assets, how do you keep on trading, and what happens to debt. I would like you to stay until the end. There's a great liquidation handbook that is listed on Amazon that I wrote that you are welcome, that I'll give to you, very welcome. You can give it to your clients so that they can just understand that there are better options for them. I'm Nanika Prinsloo. I'm an attorney and a conveyancer. I'm a commercial lawyer. I've been doing insolvency since 2008, full-time. This is all I do. I've only done insolvencies 100% for the last 10, 11 years. And I've helped hundreds and hundreds and hundreds and hundreds of business owners to get rid of problems, especially SARS, my arch enemy, because SARS just paralyzes most business owners. But it is possible that a liquidation can write the debt off, and I'll tell you how. Why do I want you to work with me? Why am I inviting accountants? Because we're both professionals, and I think from our perspective, we can help the client as a team. I work very personally. I don't have a secretary. I do all my work, well, not all of it, but I mean contact-wise and consultation-wise. Forgive me. And I work with a lot of accountants already, and for many years, and we work as a team. So it's our client. It remains your client, not taking your client away, but I come on as your team, so I strengthen the services that you give. I'm 100% focused on the client, and I work holistically. I don't just talk about liquidation. I talk about how can we help the client get out of this problem so that he can continue with trade. But if he doesn't want to continue, how can he stay on his feet, or she? I need to know if everybody's here. Are you still here? We've got a number of people attending. Now I've done and messed it all up again. But yeah, thanks for that. So what is liquidation? Liquidation is not just getting rid of a company that's in financial trouble. The liquidation process is actually a restructuring process in that you help the client get, yes, thank you for raising your hands. It's a process to help clients with businesses who want to continue to trade to restructure so that we enable them to do that. And liquidation is just one leg of it. It's not the end of the business. It's actually just one leg of a process to get the client, keep the client going. 100% able to trade. You're rid of debt. You can start fresh over, and usually that's just what most businesses need. The words I often hear from most of my clients is, the trouble has been coming the last 2 years. I should have done this before, but COVID just closed me down. It knocked me over. But I must continue because this is my only source of income. And that we can do, and that's exactly what I specialize in. So liquidation is prescribed by the Companies Act, and I'll talk about that now, and is regulated by the Insolvency Act. And the interesting thing that happens with a liquidation or a sequestration is that all the creditors must come together. So instead of one creditor or the first one taking the client's assets, selling it, closing the business down completely, they must stand in a queue and be paid in a certain order. So I like the structure of it because A, it takes the problem away from the client. They don't harass and attack him and take his stuff and take his money, and they've got to stand in queue, they've got to wait, everybody's got to calm down, got to wait for the liquidator, who's the orchestrator of this process in the end, and deal with whatever is available in a certain order. If they don't do that and they don't want to partake in the liquidation process, they must write their debt off and then they've got no say. But at least it takes the pressure off the client almost immediately. So when must you liquidate? Section 22 of the Companies Act says that that you cannot trade in insolvent circumstances. Basically that means if a company cannot pay its debt or the liabilities exceed the assets, you must liquidate the company. Must liquidate the company. It's not an option. It's not a choice. You must liquidate the company. So I would think that most businesses in this country need to liquidate immediately, but people don't know that, number one. They don't know this duty on them, and two, what people do is they try to survive. They try to trade out of the problem. They try to get better. They find solutions. They borrow more and more money, which is devastating. But if you keep Section 22 is the start of it. So if a client knows, if I cannot pay my debt, I must liquidate, it makes it less emotional because you're fulfilling a duty and complying with an act. So it makes the decision much easier and faster. And then I must scramble to restructure very quickly. And so the sooner you liquidate, the sooner you can recover, because you've seen it, I've seen it. People, the problem starts. I spoke to two people the other day. It was just shocking to hear. They're in their 70s. When they bought a business 8 years ago, when they bought the business, they had 2 houses. They had 2 cars free paid. They had money in the bank. 8 years later, without noticing it, they sold one house to save the business. They sold the second house to save the business. They sold their cars to save the business. To the point where now they are bankrupt completely. They're living with a friend and they've got absolutely no money in their 70s. I mean, if they spoke to me 7 years ago when the problem started, we could have saved their houses and their cars. So liquidation is immediate. You must do it immediately, and then you can recover immediately. And people like those people with 8 years of a business where they just invested everything they own into a failing business. They didn't notice that the business is failing. They're like a person on the lie-low. They were so busy plugging holes that they forgot that they can get off and swim to the shore. Actually, they didn't know that they could do it. That's the tragedy here, and that's why I would like all of you and us to know that this is how it works. And stop the minute there's a problem. Stop the minute there's a SARS issue. Stop, liquidate, walk away, because it stops you to get. It helps you to get rid of the problem and stops you managing and trading out, and all your money goes. You know how it goes. People just go and borrow more and more money, and they don't realize it's not working. So what can liquidation do for your client? Apart from the first two on that list where it's an emotional relief. I mean, I think if every business owner starts a business and he knows that if things go wrong, I can liquidate, they will do business differently. Because at the moment, people think that liquidation is the end of the world. Everybody believes that they must pay their debt. And if you don't pay your debt, you're not a good little citizen. That's just how we are. That's how South Africans are. We're good people. We do the right thing. But liquidation is a better choice for a businessman who has financial problems. And the main thing is that it gives you a chance to get a fresh start, debt-free. If you didn't sign personal surety, we've got to talk about that, and no more creditors chasing you, because the one thing that drives them crazy and up the wall and takes them away from being able to focus is that the creditors drives them up the wall. So when the client's ready to proceed, I will give them a free 15-minute consultation. I will tell them exactly how it works, and I'll analyze the situation and tell them what they must do and can't do. I do work online, especially now. I don't particularly see people. If somebody really wants to see me, I will make a plan. But because I'm based in Gordons Bay and in Somerset West, in the Western Cape, but I work absolutely all over the country. And you will see, as I explained to you later, that liquidation, when we do it in the company's offices, is purely administrative. So we don't have to sit with each other, and the documents are couriered back and forth. And people talk to me directly. You don't have a secretary or a switchboard or anybody. You talk to me. If you're still with me, send me a yes, please. Okay, so there are two ways to liquidate a company. The one way is we can go to the High Court, and the other way is to do it in the company's offices. The High Court liquidation is expensive. It takes about 2 months. Nowadays, with the court rolls that are in a mess, it will probably take longer. In Johannesburg, I know the court rolls are already in February. So, we have the disadvantage in the other provinces other than the Cape. In the Cape, we choose our court days. We've got motion court every Thursday, so we just put it on the court roll. In Johannesburg, Pretoria, and Natal, you've got to apply for a court date. It's chaos at the moment, so I'm not even considering High Court liquidations. I only go to the High Court with an application if there's a deadlock between directors or members, or if there's a serious problem somewhere else. Otherwise, we go to the company's office. It's cheaper, it's faster. It takes about 2 weeks to do the whole process. Sometimes it takes 3 days to get a company liquidated, and the cost is substantially lower. It's called a voluntary liquidation by creditors, which means that the directors and the members must be in agreement. So if everybody is willing to sign the documentation, if there's more than one director or member, then we can do the company's office liquidation. And how does it work? I send a form to the client. Client completes it, returns it to me. We draft the documentation. I arrange signature. They email it back to me. We lodge the emailed version first. That means we speed up time, courier the originals to me, and then we lodge it at the master of the High Court after liquidation so that the master can liquidate the company. If it's a High Court liquidation, it takes much longer. There's longer documentation to drive, and I would like them to actually sit with the client because it can get complicated. The effects of liquidation is that immediately, the minute there's a liquidation, all debt's written off. They're not allowed to continue with legal action against the company. Creditors are not allowed to harass the directors from the point of view from the company. Let's leave sureties for a minute aside. I'm going to talk about it. And most importantly, SARS debt is written off. SARS does not collect debt after liquidation. There's the sureties. If they sign personal surety, they must still pay the debt, or they must consider sequestration. That's another topic for another day. If you, in the meantime, want more sequestration information, I'll gladly give it to you. Got an ebook on it. So that way, if the client sequestrates, he blocks the debt that he signed personal surety for. If he wants to sequestrate. If he doesn't want to sequestrate, then we must move his assets around to protect it timeously so the creditors can't get hold of it. We've had 100% success rate. I've never, ever, ever, ever had a failure on any liquidation, never had problems, never had queries, never had anything. And all of our business owners who wanted to continue to trade have built successful businesses. In fact, they are better off afterwards because they've learned their lessons, they've paid their school fees, and they now know that this is the worst it can go. Liquidation doesn't really affect you. It's a mechanism that you use to restructure yourself, and then, I don't know, they're different. They do business more confidently and better because they learn a lot, because I coach them a lot. I teach them their rights. I teach them about assets. I teach them what creditors can do, so they come out better on the other side. So once a company is liquidated, what happens? First of all, the master of the High Court will appoint a liquidator, and the liquidator's job is to wind up the insolvent estate. So liquidation is a two-leg process. The first leg is to get the company liquidated. That's what I do. And then the second leg is the liquidator to wind it up. That process, nicely enough, the client's not really involved in it. The liquidator doesn't report to the client. They don't talk to the client. The only time they talk to the client is if they want any information from the client. And usually they want the bank statements. That's the one. They're not even interested in the financials. If there are financials, they'll take it, but they're more worried about what happened in the bank account the last 6 months. He will hold meetings with creditors where they must prove a claim, because the fact that somebody's listed as a creditor doesn't make them a creditor. They must still prove that they're a creditor. And proving a creditor means that you must arrive at one of these meetings with a contract and then a certificate of balance to prove the nexus between you and the client, the company. And then if there's any asset that the client will need, that's the time when you'll buy it back from the liquidator and you can pay it off. What happens to staff in a liquidation? Now, let's talk about people who do not want to continue with business and people who want to continue with business. The guy who does not want to continue with business, who's going to close it down and do something else, his staff that he doesn't want, he can just pay them their last salaries, or she, and they can then either pay a retrenchment package. You shouldn't, but we all have a heart, and if there's money, the liquidators look away if you pay the staff. You're not really legally allowed to pay one creditor over the other, but as I say, for humane purposes, they don't mind if you pay the staff a retrenchment package if there's money. If there is no money, then you don't pay it, and the staff can claim it from the liquidator in the insolvency process, in the winding up process afterwards. Usually they will get nothing because SARS will be before them, or a rental, a landlord will be before them in the queue. So, and depending on the number of assets, usually they get nothing, but there's the possibility that they can try. And then the business owner who wants to continue with business can take the staff over to the new company, and the new company can employ the staff with their work history, which means the old company doesn't have to pay retrenchment packages. It only has to pay wages. If there's no wages there payable, if you haven't got money to pay the wages there, but the new company will, then if you want goodwill of your staff, then what this new company can pay those wages, and then there's no retrenchment packages payable in the old company because they won't lose any of their benefits. So the new company takes them over with their work history, and when the new company one day wants to retrench them, then the new company will retrench them from the date that they started working for the old company. So it will get a little bit expensive for the new company, but at least that's a way to defray the problem and keep your staff happy. So what about assets? If assets are financed, they will go back to the bank unless the client wants to keep them. Then he must finance them or refinance them, or somebody else must finance them for them. If they are fully paid, you can buy them back from the liquidator because you buy it back at second-hand auction value, which is very low. Especially now, I think auction values are going to drop dramatically because, especially in the hospitality industry, because there are hundreds of businesses, thousands of businesses, from what I understand, being liquidated at the moment. And my liquidator that I work with tells me that it's going to be a problem. Rental agreements is a big one at the moment because most people who had to close couldn't pay their debt. The landlords are now getting irritated and frustrated and getting aggressive. So again, we've got to talk about people who want to continue with the business and people who close it down. People who close it down will have to cancel the agreement as soon as they possibly can. They must move out of the premises as soon as they possibly can, because the longer you stay in agreement, the bigger your liability becomes. And the directors would have signed 99% of the time, you sign personal surety for that debt. So you've got to limit your damages and you've got to limit the landlord's damages. So usually when there's a term in the agreement, the landlord will try and hold you liable for the full term. But here's the trick. If you cancel the agreement as soon as you possibly can, the agreement is cancelled, and the landlord cannot hold you liable for the full term. You are allowed to cancel even if the contract says that you can't, because it's just attorneys pushing their luck, but you can cancel an agreement. And the landlord then, the onus then shifts to the landlord to limit his damages. By limiting his damages, he has to find a new tenant as soon as possible. You often find that a person wants to sell the business. I'm busy with a matter like that now, where the landlord is so full of nonsense, he won't let a new buyer buy the business, which means he is basically prohibiting the current tenant from limiting his own damages and increasing his damages. So like, how will my client pay those costs? I'm telling you, the landlord will have to prove his damages once you've cancelled, and he will have to prove to court then that he did his best to refill the premises. And then the damages must be proven. So how are you going to prove your damages? You've got to show that you did your level best to find a tenant and couldn't. You can't just sit back and say, I've got somebody in here for a term, he's got to pay. So, but if the client is going to stay in the premises and want to continue, then he's got to negotiate with the landlord. And the eye is on the sureties. You want to limit your suretyship as much as possible. And then with regards to the landlord, I just want to stay there for a second because this happens to nearly everybody, is that the landlords, being aggressive, they tend to put a lock on the doors. Now, that's unlawful. The only person that can put a lock on the door, even if you're in arrears, is the sheriff, and he must have a court order. A rental interdict summons must be issued, and he can lock you out. Because the landlord has a retention right, he can apply for an automatic rental summons interdict, which can be issued on the same day, and the sheriff can arrive on the same day with the lock, and then you can't move anything in or out. But if the landlord out of his own accord go and lock the premises, then that's a problem because that's unlawful behavior. The problem with that is the only way to get him to pull the lock off is to cut it off, but then you've got a fight of another kind, or then go back to court and apply for an interdict to force him. But by the time a client has to liquidate, who's going to go to court. So then the best is to move out before that happens. So if you see there's problems with a landlord and the client wants to continue with the business and he needs the assets, then the best is move out as soon as possible. Move out, then give your cancellation, and it is lawful. There's nothing prohibits you to do that. And then if there's work that's not finished, a lot of clients take deposits and 50% deposit, do the work, and then get paid for the balance. A lot of businesses get in trouble because they use those deposits to run their business with instead of completing the work with. So now they come to a position where they can't finish the work, but they've used the deposits. That's a big problem because you're not allowed to use a deposit. If I pay you money for reason X, you can't use it for reason Y. And it actually constitutes fraud. And you can be criminally charged for that. Don't tell that to the clients. They must just know that come hell or high water, if you've got deposits that you've taken in and you can't pay it back, you've got to find a way to finish the work. Because if anybody of the clients wisen up and anybody advises them to lay a criminal charge, the client will end up being criminally charged. And I've had that 3 or 4 times happen. But I could also say in the same voice, as serious as it is, the main purpose is to collect the money back, not to get a criminal charge. So in each and every case, I've had it 4 times happen where clients were criminally charged because of a client that was advised correctly. Most people don't know it, but if they're correctly advised by their clients, or by their attorneys, what they want is their money back. So in all the cases where the client made a payment arrangement, they withdrew the charges. But clients must know how serious it is to take deposits from people and not finish the work. They must just find a way to finish the work or immediately enter into a payment or repayment arrangement with a client. That's the one thing I would say they must keep out of the liquidation. Then you and I must talk about the director's loans. You know how you do book entries for the purposes of income tax to save the director income tax, where his drawings and his salary are put through as a loan. That's great for SARS purposes and for accountancy purposes. But it bites you when you liquidate because now you sit with a loan, the director, which is essentially his own money, and the liquidator is most definitely going to call it up. Most guaranteed he's going to call it up because it's a fantastic asset. So by the time a client liquidates, he must not have a director's loan. So you can, my understanding, and that's how we've been doing it for the last 10 years from the accountants and auditors that I work with, is that you can go back 3 years, and there's one of 2 ways to do it. You can reverse it to a salary and let the pay as you earn be payable, or if the company made profit, you could reverse that money back into the company and then pay it out as a dividend. You can only pay it out, of course, as a dividend if there was a profit, but it's another option to do it if you don't want to do the salary way. But there mustn't be a loan by the time the client liquidates. And look, if it's really a loan, then it must stay there. But if it was only salary, then we all know it's a book entry. The liquidators know it's a book entry as well. Then you just got to fix it up. The pay-as-you-earn that's going to be payable is going to be payable by the company, and the company is going to be form part of the liquidation, so that's going to be written off. And then our best friend SARS, that I want to invite for a cup of tea. All SARS, except the customs and excise debt, is written off, all taxes. I can tell you that I've liquidated people. One guy owed SARS 100 million rand. He had a mine. SARS didn't even bother to prove a claim against the insolvent estate, and they were huge assets. I had people with 38 houses who owed SARS 90 million rand. SARS would have gotten paid because all the houses were sold. SARS stood second in line. It was the time when houses went for high prices. SARS didn't prove a claim. Something happens at SARS where they don't prove a claim against an insolvent estate. Don't know why. Touch wood. Don't ask me why. But to date, not one of the hundreds and hundreds of liquidations that I've done has SARS taken any legal action against any of our directors. I've had 2 cases where SARS did try and hold the director personally liable, but both were because they were committed. They said that the directors committed fraud, that they under-declared VAT and that they over-declared output tax. So in my experience, SARS does not continue to collect any debt from directors in their personal capacity. And if they do, we can deal with the director. That's why I have this conversation with them about their personal assets by the time we liquidate it. If client doesn't want to liquidate, to sequestrate, personally, we look at how move his assets now while we're busy with this restructuring process. Look at his income, how he earned his income, where can we put his money in a trust or a new company, and so on, so that we can avoid being attacked by SARS. Clients are not directors and members are not blacklisted because of liquidation. Nearly every person who phones me, every client who phones me wants to know that. The director is not affected by the liquidation because of Section 22 of the Companies Act, because there's an obligation on the director to liquidate the company when the liabilities exceed the assets. Sureties, I'm so unhappy about sureties. If the client did sign surety, I always tell them find that out first. If they did not sign surety, it's a happy days, and we have a little tea party again, and we liquidate and the client walks away. If he did, then he's got to make plans, or we've got to sequestrate him, or we've got to at least deal with his assets. And then in the same voice, if the debt of the company is R1 million and he signed surety for R1 million, we're not going to liquidate him. He has to liquidate, it has to sequestrate. What's the point of liquidating when you sign surety for all of the debt of the company in any case? So then I have to look at his personal position. And definitely can keep on trading. You can have 50 companies that are liquidated and 50 that are more that are successful. There's nothing that prohibiting any director to have as many companies as they like to continue to trade. I've got a client, he only trades up to 990,000 Rand, then he liquidates, so he doesn't have to pay that. Then we register a new company, what he does, and we liquidate him in 990, and there's nothing prohibiting him to do that as well. Personal assets liquidation does not affect personal assets at all. The only way it affects the client is if he's got surety and he doesn't make payment arrangements. And I've already spoken about protecting assets. Sequestration is a fantastic tool to get rid of debt in your personal capacity. In fact, if the client signs surety for too much of the debt, I don't even bother liquidating the company. We only sequestrate him because that's all we're worried about. The company is becoming a shelf with nothing in it in any case. So what our creditor is going to do, but we rather sequestrate him so that it blocks all the sureties. And that is the end of our webinar, but I've got a few things more to say. You and I work with money, with people with money, and what I've learned in the 10, 11 years that I've done this, and after speaking to thousands of people, it doesn't help to let your money pay backwards. You've got your money has to move forwards, meaning that if you want to pay debt, you've got to make triple what you're making to just break even, because you've got to pay debt backwards and you've got to get the income to break even, and then you've got to make it the third time to go forward, to make a profit. And in these trying times of economy, it doesn't happen. So if you earn R1, that R1 must work for you to your maximum. And liquidation and insolvency gives you that opportunity to do just that, to make your money work for you. And I feel very strong about it because we're in trouble in South Africa. We don't have a government that's going to support us. There's no good pension for any of us. There's no good medical. You've got to pay for all things yourself. So clients, and especially the older clients, I'm horrified with those two people that I spoke about earlier that's in their 70s and they've got nothing left. They've got no income. What are they going to do? So the duty on each South African to get rid of their debt as soon as possible, and if you can pay it by all means, but I'm talking about people who can't, is do insolvency and get rid of it so that your money can work for you, so that you can put money away for your retirement and your medical things which are coming, and work is getting less. I could go on for it for a long time, but to me it's imperative that people understand that this is a better option in these trying times as soon as possible. So I'm hosting this webinar because I would love to work with you. You are the first line of defense. Clients come to you first. You know before the client does most of the time, because you do the books, that they are in financial trouble. And I would love it if you would refer your work to me, or clients to me. I would love to work with you, with your clients, and help them. How do we proceed? At the end of this webinar, I will send you the ebook if you want it. And then Also, if you want, we can have a one-on-one meeting, happily to meet you. We can have a Zoom party and have tea, and I'll even email you a cake, and we can have a good chat. And the working together is that you can, if you identify a client, you can give me the number, or we can have a Zoom meeting, or we can have a conference call where you sit in and we analyze the client and help him, and I'll tell him what to do. But why choose me? Why have all the attorneys would I want you to work with me? Because I'm passionate about what I do. It's all I do. I'm a specialist. I'm really not doing, I've stopped doing all other legal work because this is so amazing, because it's like doing magic, helping people to really get out of a big mess and putting them back on their feet. I think it's the most awesome work to do, and also believe that our South African economy, entrepreneurs need it desperately at the moment. Everybody's down in the dumps. They're desperate. They don't know what their options are, and I would absolutely love it if more people get the opportunity to talk to me, because I've got a lot to tell them. I've got a lot to teach them, and you can help me to do that. And then I give personalized service, as I already said. I'm always on call. You can call me anytime. If you sit with your client, phone me. If you have questions about a client, phone me. Anything, just phone me or email me. Questions that I've got for you is that the 8 o'clock time suit you for this webinar? Would you like more webinars on legal topics? I'm planning to do more webinars on sequestration, and then again on rehabilitation, and also on the rights of a business owner and what they should get in place when they start a business. Usually I catch them at the end of it, but I wish I could get them at the beginning of it. There's my free liquidations ebook. Will you let me know if you would like it, and then we will email it to you. Thank you very much for attending this webinar. It's the only webinar on insolvencies in the country, in the history of South Africa. If you've got any questions, now is the time to please type them and I will deal with them. In the meantime, there's my contact details. My email is there, Nanika. My website is Empower Law. There's much more information there. And I just want to thank Jacques in the background, the silent partner. He's an IT tech wunderkind. He has run this webinar for me and all my other tech work, and everything that you see Jacques does is just great. There's his contact details if you want some digital marketing done and extra work done. Thank you very much, Jacques, for that. And that is the end of our webinar. Let's see if there are any questions. Would you like to type your questions? I've got no questions. Have you got no questions, people? Talk to me. Let's see what you've got. If there's nothing that you can think of at the moment, just email me or SMS me or WhatsApp voice note me. That's a nice favorite because we're all so busy. And there's no questions. So I think I've told you everything you need to know. If you want any more information from me, email me. Or I'm very cautious of spamming anybody. I don't want to spam anybody, ever. I'm very sensitive about that because we're all very busy and you don't want this inundation. But I would like to make contact with you, at least introduce ourselves on a personal level. Let's see, there's chats, but I can't see it. Now I've got to ask Jacques how to get the chats up. You must forgive me. I want to talk about something while I'm trying to get the chats up. There you are. Okay. I want to ask, I see the word Wayne, business rescue practitioner. I wanted to say, I'm glad I need to talk to you. I'll contact you afterwards. We will definitely send you the slides. There will be a replay of the video as well that Jacques will send to you. Business rescue, it's a good, valid question. No, it's not a question, but I've got to stop the share. Anyway, I'll just want to talk for a minute because I get confused very quickly. Forgive me, I'm not a tech person. Business rescue. Why don't businesses go for business rescue straight away? We've got a business rescue practitioner on the panel. I just want to explain why I go for liquidation first. Business rescue for me is fantastic, and you can help me right if I'm wrong. But if you have a business that are temporarily in trouble, and there's work on the horizon that's definitely coming in, you've got a contract that's coming down in October, you just have temporary cash flow issues, then business rescue is the way to go, not liquidation, if you can really save the company. But there must be something concrete, definitely concrete on the table, because if there isn't, all you're doing is you're postponing the inevitable, because the business rescue practitioner is not going to magically find the solution. All the business rescue practitioner is going to do is going to manage the business to see if it can get out of trouble. And 9 out of 10 businesses, in my experience, that have been in business rescue end up in liquidation. So that's why I say, cut the arm off now, start over as soon as possible. And the only time you will business rescue is if there's really a solution. I'm going to see the chat. Let's see. Yes, there we are. There's no questions. Thank you so much for attending my webinar. I'm excited to have had you. I look forward to working with you. And bye-bye. I hope you have a very successful day. Bye.